The decision I have chosen to discuss in my current trends case brief is the Supreme Court decision in the Queen v. Jones case. The matter came before the Supreme Court by way of appeal from the Ontario Court of Appeal. The matter was heard on March 23, 2017, and judgment was rendered on December 8, 2017. The neutral citation for the decision is R.V. Jones, 2017 SCC 60. The appellant, Tristan Jones, was convicted of several firearms and drug trafficking offenses. The firearms conviction was secured based on a record of text messages seized from a TELUS account associated with a co-accused. The messages had been obtained by police through the use of a production order made under the authority of Section 487.012, now 487.014, of the Criminal Code. The production order was granted during the course of an investigation focusing on firearms trafficking in the Ottawa, Ontario area. The order directed TELUS to provide the police with copies of its stored records of any in- and outgoing messages on an account associated with Mr. Jones' co-accused, Mr. Waldron. The targeted account was registered in the name of Kurt Giles, the Giles account. When the records were examined, a text message between the Giles phone and a phone used by Mr. Jones, registered in his spouse's name, revealed a plan to transfer a firearm in a manner contrary to the provisions of the Criminal Code. Once this and other texts were revealed, the police obtained two Part 6 authorizations relating to the phones of Mr. Jones and several other suspects. Communications intercepted pursuant to the authorizations resulted in the granting and execution of various search warrants. Evidence seized led to the various charges that ultimately resulted in Mr. Jones' convictions. Prior to the commencement of his trial, Mr. Jones commenced an application seeking to exclude the texts from being admitted as evidence against him. He argued that the manner used by the police to obtain the texts, specifically the use of a production order, rather than a wiretap type authorization available in Part 6 of the Criminal Code, violated his Section 8 charter right, which provides everyone has the right to be secure against unreasonable search and seizure. If he were to succeed on this basis, his further argument would be that the authorizations obtained subsequent to a review of the results of the production order that led to search warrants and further evidence being obtained were also improperly obtained, and the evidence gathered pursuant to same should also be excluded. The trial judge found that Mr. Jones did not have standing to challenge the production order under Section 8 of the Charter, as he produced no evidence establishing that he was the author of the relevant texts, and therefore could not establish a reasonable expectation of privacy in the subject matter of the search. Jones was subsequently convicted at trial. His appeal against conviction was dismissed in a majority decision of the Ontario Court of Appeal that upheld the trial judge's ruling regarding the Section 8 standing issue. In March 2017, the Supreme Court of Canada agreed to hear a further appeal. By majority decision, the appeal was dismissed and the validity of the production order upheld. In rendering its decision, the court addressed three questions that pertained to two major issues that needed to be considered in order to dispose of the appeal. The first issue considered was whether Mr. Jones had standing to challenge the production order. Specifically, the court asked itself, A, in his Section 8 charter application, was the appellant entitled to rely on the Crown's theory that he authored the text messages in order to demonstrate a subjective expectation of privacy in the subject matter of the search? And B, was the appellant's subjective expectation of privacy objectively reasonable, and thereby able to satisfy the criteria required for him to have standing to make his Section 8 claim. The second issue considered was whether the production order provided lawful authority for seizing records of historical text messages located in the hands of a service provider. The court began by considering the protections set out in Section 8 of the Charter. Specifically, everyone has the right to be secure against unreasonable search or seizure. and then set out the general rule regarding what a charter claimant must prove in demonstrating a Section 8 charter breach. The claimant must prove both the existence of a reasonable expectation of privacy in the relevant subject matter and the unreasonableness of the search or seizure of that subject matter. The court then acknowledged that the case before it involved an analysis of both stages of the Section 8 inquiry. The court began its analysis of whether Mr. Jones had standing to challenge the production order by determining whether he had a reasonable expectation of privacy in the subject matter of the search by examining the totality of the circumstances of Mr. Jones' case. Using guidelines relating to a claim involving informational privacy set out by Justice Cromwell and R.V. Spencer, the court turned its mind to the following. 1. An examination of the subject matter of the alleged search. 2. A determination as to whether the claimant had a direct interest in the subject matter. 3. An inquiry into whether the claimant had a subjective expectation of privacy in the subject matter. And 4. An assessment as to whether this subjective expectation of privacy was objectively reasonable, having regard to the totality of the circumstances. The court's first task was clarifying and defining the subject matter of the search. It was established that the subject matter of the search conducted pursuant to the production order was the electronic conversation between Mr. Jones and the user of the Giles phone. Next, the court addressed the issue of whether Mr. Jones had a direct interest in subjective expectation of privacy in the subject matter of the search. The lower courts had put an end to Jones' Section 8 application before any relevant analysis could occur, indicating that his failure to prove or even attempt to lead any evidence that he was the author of the text messages meant that he did not have standing to pursue a Section 8 charter challenge. The court noted that it was able to infer that if Mr. Jones authored the text messages, that he had a direct interest in their subject matter, as they were capable of describing aspects of his biological core. The court further noted that as the author of the text messages, it was an uncontested fact that he had a subjective expectation of privacy in the records of them stored by the service providers involved in their transmission. It followed then that the real question in determining this issue was whether or not Mr. Jones should have been able to rely on the Crown's theory that he was the author of the text messages for the purpose of establishing his Section 8 claim. In answering this question, the court considered both Mr. Jones's argument that he did not have to admit to being the author of the text and that he could rely on the Crown's allegation that he was the author without admitting it, and that the Crown's position that the claimant in a charter of voir dire bears the burden, typically through the introduction of evidence, of establishing the required criteria of standing, and that Mr. Jones' claim must fail because the accused was not entitled to rely on the federal Crown's theory in the voir dire, and there was no admission of his identity as the sender of the text anywhere in the pre-trial motion record. Highlighting the modest evidentiary foundation required to establish the subjective expectation element in the totality of the circumstances analysis, as well as the principle against self-incrimination in criminal proceedings, the court ultimately determined that Mr. Jones was entitled to rely on an exception to the rule that a charter applicant bears the burden of persuading the court that his charter rights or freedoms have been infringed or denied, because the Ontario Crown Council tendered the text messages to prove he was the author of their inculpatory contents, and admitted in the voir dire that the evidence was very clear in that respect. The Crown's theory led to the presumption that Mr. Jones was the author of the text messages for the purpose of pursuing his Section 8 application. After determining Mr. Jones' entitlement to rely on the Crown's theory to establish a subjective expectation of privacy in the subject matter of the search, the court's focus shifted to whether such expectation of privacy was objectively reasonable. While the lower courts had held and upheld a finding that Mr. Jones did not have a reasonable expectation of privacy in the text messages, the court rejected the two lines of thought that led to their respective findings. The first line of thought supported a general proposition that Mr. Jones gave up any right to claim a reasonable expectation of privacy to the messages obtained from TELUS because he voluntarily relinquished control over the message once he sent it. The second line of thought centered on the fact that 1. Mr. Jones was not a party to a confidentiality agreement with TELUS, and 2. The production order and seizure of the text messages targeted a TELUS account in the name of a third party, and therefore he did not have an objectively reasonable expectation of privacy. In supporting its rejection of both the above lines of thinking, the court cited existing jurisprudence that considered the requirement for a purposive interpretation of charter rights, highlighted the purpose of the Personal Information Protection and Electronic Documents Act, SC 2000, C5, PIPEDA, as being the establishment of rules governing, among other things, disclosure of personal information in a manner that recognizes the right of privacy of individuals with respect to their personal information, and reviewed existing case law that noted that while, by its very nature, use of the Internet leaves a trail of digital breadcrumbs with the service provider that are capable of disclosing a history of one's private activity on the Internet, one still has a reasonable expectation of privacy in the subject matter of the search, even if an Internet user cannot fully control or even necessarily be aware of who may observe a pattern of online activity. Citing the case of R.V. TELUS Communications Co., the court recognized and accepted the position that telecommunication service providers act merely as a third-party conduit for the transmission of private communications. The court in TELUS also acknowledged that it is expected and reasonable that a service provider will keep information private where its receipt and retention of such information is incidental to its role of delivering private communications to the intended recipient. The court drew a parallel between the Jones case and the Spencer and TELUS cases, ultimately ruling that relying on the fact that Mr. Jones relinquished direct control of the messages vis-a-vis the service provider to deprive him of standing in a charter challenge did not promote a purposive approach to a Section 8 charter analysis. On that basis, the court found that Canadians are not expected to become digital recluses in order to maintain some semblance of privacy in their lives, and accordingly relinquished direct control over the text messages to a telecommunications service provider did not deprive Mr. Jones of having a reasonable expectation of privacy in the messages stored by such provider. In moving on and rejecting the second line of thought, the court's review of the case of R.V. Gombach and the Spencer case highlighted the principle that the fact that the person claiming an expectation of privacy in information ought to have known that the terms governing the relationship with the holder of that information allowed disclosure may not be determinative in assessing whether the claimant had a reasonable expectation of privacy. The case had further emphasized the fact that an individual who used the service but was not a subscriber to the service, and therefore not a party to the contract with the service provider, would not be aware of the contract's contemplated dissemination of the subscriber information and therefore provided little assistance in evaluating the reasonableness of an expectation of privacy. The court concluded that since the presence of a confidentiality agreement could not, acting alone, and in a view of the totality of circumstances of a case, defeat a claim of reasonable expectation of privacy, the absence of such an agreement as in the Jones case could not defeat his claim. The fact that the production order targeted a third party's cell phone account was found by the court to have no bearing on Mr. Jones' claim of reasonable expectation of privacy. It made no difference whether the text messages were accessed through authorization to examine the recipient's account or the sender's account, as in either case the text messages were in the control of the service provider. Satisfied that Mr. Jones had a reasonable expectation of privacy in the text messages obtained pursuant to the production order, and therefore had standing to challenge the search resulting from the issuance of the order, the court moved on to complete the reasonableness of the search component of the Section 8 analysis by addressing whether or not Historical text messages can be lawfully obtained by means of a production order made pursuant to Section 487.014, Section 487.012 at the time of the order of the Criminal Code. Mr. Jones argued that the lower courts had erred because seizure of the text messages from TELUS amounted to an intercept or functional equivalent within the meaning of Part 6 of the Code, and required the police to obtain a Part 6 wiretap type authorization in order to seize the relevant information from the service provider. Mr. Jones' argument regarding the reasonableness of the search did not propose that the use of a production order was not authorized by law. It disputed whether Section 487.012 of the Code was the proper source of authority for the particular search. The parties agreed that the text messages are private communications protected by Part 6 of the Code, but the question for the court lay in interpreting whether the word intercept included the production or seizure of historical text messages held by a service provider. The appeal dealt only with historical messages and not those involved in the transmission process at the time the order was granted. The court considered extensively, through a review of existing jurisprudence, 1. The purpose of Part 6 of the Criminal Code, specifically the protection of an individual's private communications from interception and surveillance by the state. 2. The structure of Part 6 and the distinction between intercept and disclosure. 3. The plain meaning of intercept and its surrounding context within Part 6. And 4. The specific investigative technique engaged in by the police in the Jones case. It arrived at the conclusion that the use of the production order was a proper authorization for the seizure of the historical text messages held by TELUS because the order did not authorize or even potentially authorize the disclosure of any text messages not yet in existence or still in the process of transmission at the time the production order was issued. In summary, the court found that Mr. Jones had a direct interest in the subject matter of the search and a reasonable expectation of privacy regarding the text messages disclosed under a production order obtained by the police pursuant to Section 487.012 of the Criminal Code. He therefore has standing to advance a Section 8 charter application challenging the reasonableness of the search, which authorized the disclosure of the records of the historical text messages held by TELUS. However, after reviewing the relevant legislative authority and existing jurisprudence and legally binding precedents, the majority of the court concluded that the search was reasonable and the use of a production order was lawful authority for said search. In reaching this conclusion, the court emphasized that the issue in the Jones case were determining on the basis of the limited scope of the search, specifically the historical text messages in the hands of the service provider, TELUS, that related to the electronic conversation between Mr. Jones and the use of the Giles phone. This SEC decision in the Jones case was an important and useful one because it provides a comprehensive outline of the analysis required to determine the outcome of an application alleging a breach of an individual's Section 8 charter right to be protected from unreasonable search and seizure. The availability of different investigative tools to trigger different types of searches and the parameters dictating when each search will be considered lawful and reasonable was a concept that I found very interesting. The thorough analysis provided in this decision also offers a great deal of insight into various legal concepts and principles, such as subjective expectation of privacy, reasonable expectation, and the concept of having standing to advance a claim. The degree of interaction between and among various regimes of legislation, the Criminal Code, Personal Information Protection and Electronic Documents Act, and the Charter, also became evident when reading this decision. In the Jones case, the court made a very clear distinction between search and seizure as it pertained to historical records of text messages held by a service provider versus as it pertained to messages not yet in existence or in the transmission process, prospective messages. Historical messages could be seized by use of a production order rather than through the use of a Part 6 authorization, with a later authorization requiring a higher threshold to obtain. Do you agree that the distinction between historical and prospective messages warrants the use of two distinct types of lawful authority for search and seizure operations?